The biggest mistake I see active victims make here in Indiana is assuming that a normal ER scan means their brain is perfectly fine. Insurance adjusters love to use these clear scans as a weapon to kill your claim. But as a lawyer and former chiropractic physician, I know exactly how to beat them at their own game. If you don't know how to prove the hidden brain injury to a jury, you are leaving your financial future entirely unprotected. Today, I'm breaking down the exact 5-step medical legal blueprint we use to turn an invisible injury into an undeniable reality in an Indiana courtroom. Look, I get it. You were in a violent car wreck or a bad fall. You went to the emergency room in Indianapolis, Gary, or Valparaiso, and the doctor told you, good news, your CT scan is clear, go home and rest. But weeks later, you realize you're not fine. You're dealing with crushing headaches. Bright lights make you feel physically ill. You're snapping at your kids, forgetting where you parked your car, and you can barely get through the standard workday. The worst part? You look completely normal on the outside. Your friends don't get it. Your employer is losing patience, and the insurance company is practically calling you a liar. They see a clear medical report and assume you're faking it for a payday. It's incredibly stressful, isolating, and unfair, but you don't have to fight this blind. The information in this video is your antidote to the stress. We are going to pull back the curtain on how we actually prove a mild traumatic brain injury, an MTBI, to 6 regular people sitting on your Indiana jury. Ready? Step number 1. We have to show the jury the physics. We have to explain the mechanism of injury. You see, jurors are naturally skeptical. If they don't see your skull and they don't see that it's cracked or there's some bloody gash, they don't understand how the brain got hurt. As a former chiropractic physician, I look at the biomechanics of the crash first. Your brain is the consistency of soft serve ice cream or jello, and it sits inside this hard, bony vault. You see the sharp curves there and this fluid that bathes around it. And so, if you are hit from behind, your head goes back, your head goes forward, and inside that brain, the brain shakes and could potentially push up against those bony ridges and cause tearing or sharing. You see that rapid acceleration, deceleration, even if you never hit your head on the steering wheel, the window, or the B-pillar, your brain bounces violently off the front and back of your skull. This stretches, shears, and tears brain tissue at a microscopic level. Alternatively, if your head did hit an object inside the vehicle, we need to document that immediately. Look for bruises, dynamic dash cam footage, or the vehicle interior damage. We must establish the sheer physical force of the event so the jury says, wow, it makes perfect sense why their brain was injured. Step number 2 is all about establishing your baseline. To prove to a jury that you are damaged now, we have to prove who you were before the wreck. This means gathering your prior medical history. Now, a lot of people get terrified when I ask for their medical records from 5 years before the accident. They think, Guy, the insurance company is going to use my past against me. Here is a major Indiana law secret that insurance companies don't want you to know. Indiana follows what we call the eggshell skull rule, or the eggshell plaintiff rule. This legal doctrine states that a defendant takes the plaintiff as they find them. If you had a pre-existing vulnerability, say a mild learning disability, history of depression, or an old concussion from high school football, and this accident made it significantly worse, the negligent driver is 100% responsible for that aggravation to your condition. By showing a clean or stable medical baseline prior to the crash, we can demonstrate a stark contrast. If your medical records show you never complained of chronic headaches, or memory loss, or vertigo before the wreck, that historical data becomes an incredibly powerful shield for your case. Step number 3. You and your loved ones must rigorously document your symptoms. Because a mild traumatic brain injury doesn't show up on a standard x-ray, the evidence is found in your daily struggles. We are talking about clinical markers that point directly to brain dysfunction. What are they? Photophobia. Are you wearing sunglasses indoors or avoiding bright rooms? Tinnitus. Is there constant maddening ringing or buzzing in your ears? Balance issues. Do you lose your footing just walking across a flat carpet? Cognitive and emotional changes. Are you suffering from sudden mood swings, uncharacteristic anger, memory lapses, or severe sleep disturbances? Here is my absolute best pro tip for handling this. Start a daily symptom journal right now, but do not write it like a diary full of complaints. Keep it purely factual. Write down Tuesday, May 23rd. Had to pull over driving because of a sudden wave of dizziness. Couldn't read my daughter's bedtime story because the text blurred for a few minutes. This creates a contemporaneous real-time map of your injury that your legal team and your doctors can use to cross-reference with your medical visits and prove your injury. Step number 4. You must see healthcare providers who actually know how to work up an MTBI. If you're going back to a general practitioner who just refills pain meds and says, give it time, your legal case will wither away and you're not going to get much better. You need specialized, objective, physiological, and neuropsychological testing. For example, we often recommend clients see specialists for a VNG. What is that? Video nystagmography. This test uses high-tech infrared goggles to measure involuntary eye movements. Why? Because your eye movements are directly controlled by your brainstem and neurological pathways. If your eyes aren't tracking normal, it provides objective, physiological proof of a brain or inner ear injury that an insurance adjuster cannot argue with. Furthermore, we utilize sometimes neurological and neuropsychological testing. This can involve hours of comprehensive testing with a specialist who evaluates your memory, processing speed, executive function against standard baselines. It translates your subjective symptoms into objective data points that an Indiana jury can clearly understand. We can also have the physician recommend for you specialized imaging, which might show issues with the axons or the small nerve fibers inside of your brain. Now we arrive to step number 5. If you take nothing else away from this video, remember this. The single most important factor in winning a hidden brain injury case before an Indiana jury is strong before and after witnesses. The insurance company's favorite trap is to claim that you're exaggerating your symptoms for money. If your spouse gets on the stand and says you've changed, a cynical juror might think, well, of course, she's saying that. She wants a big verdict also. This is why your family members are actually not your strongest witnesses. The ultimate weapons in our legal arsenal are objective third parties, your coworkers, your neighbors, your church members, and your friends. When a former boss or coworker takes the stand under oath and says, look, before the crash, John was the sharpest project manager on the site. He handled multi-million-dollar budgets seamlessly. Now he gets confused by simple spreadsheets. He has to write everything down on sticky notes. And I've seen him break down in frustration in the break room. When a neighbor testifies, Mary used to love tending to her garden every single afternoon. Since the wreck, I only see her out there once a month or once in a while, wearing dark sunglasses, and she looks completely exhausted just walking out to the mailbox. That is the exact moment you win your case. An Indiana jury will believe independent, working class peers far sooner than they will believe a paid insurance company doctor or your paid doctor who met you once or 5 times for 15 minutes. These witnesses build a human bridge that allows the jury to truly see the invisible damage that you have sustained. Proving a brain injury takes a meticulous medical strategy and an aggressive legal plan. If you or your loved one are fighting to make an insurance company understand the reality of your injury here in Indiana, you don't have to carry that weight alone. Now that you know the 5-step blueprint to proving a hidden brain injury to a jury, you need to know exactly what to expect when the insurance company fights back. You need to watch my next video, how to get full payment for your neck and back injuries. I'll see you over there. Guy DiMartino, meeting you at the intersection of law and medicine. Have a great day.